Do you suspect that you've been the victim of a debt law violation? If you can prove it, you could receive up to $1,000 per infraction. I'm Nicole from lowincomerelief.com, where we help millions of people save money and get free stuff. Debt is a big problem in America. Approximately 80% of Americans have debt, and it can be a financial death trap. Debt collection is a nasty business, but it usually starts with an innocent transaction. You buy something or receive something which creates a debt. This debt could be a payday loan, a credit card, or even a hospital bill. Unfortunately, if you aren't able to pay that bill within a certain amount of time, the person you owe can send that debt to a collection agency. There are two types of collection agencies: middlemen and debt buyers. Middlemen do the hard work of collecting on the debt in exchange for a percentage of what you pay. They send the rest of the money back to the original person you owed. Debt buyers, on the other hand, purchase the right to collect the debt. The original creditor basically cuts their losses and sells the debt for pennies on the dollar because they don't think they will ever be able to get the money from you. Debt buyers tend to purchase these debts in bulk. They pay an average of just 4 cents per dollar owed, which means they pay roughly $40 for the right to collect on a $1,000 debt. Debts that are older or harder to collect may cost even less. When you pay a debt buyer, they don't have to send the money back to the person you originally owed. That person was already paid when the debt buyer purchased the debt. The debt buyer keeps all of the profit for themselves, which is why so many of them will settle for far less than the amount you originally owed. Unfortunately, that also means that debt buyers can be very aggressive about collecting debts. Debt collectors are notorious for harassing, deceiving, and threatening people who owe them money, and when they do that, they may be breaking the law. And if you understand your rights, you may be able to escape the debt trap altogether. The Fair Debt Collection Practices Act, or FDCPA, is a law that limits what debt collectors can and cannot do when they are collecting on certain types of debt. This law covers mortgages, credit card debts, medical debts, and other personal, family, or household debts. It does not cover business debts. The law specifically governs collection agencies, debt buyers, and lawyers who collect debts as part of their business. These are the people who buy unpaid debts from other businesses. The FDCPA doesn't usually apply to the person you originally owed money to, but it does affect anyone that buys that debt. This law is very important because it clearly defines what debt collectors can and cannot do. It protects you as a consumer and prescribes penalties for debt buyers who break the law. Some of those penalties could put cash in your pocket. Before we go into the details, please remember that I am not a lawyer. Low Income Relief is staffed by researchers, writers, and fact-checkers. None of us are lawyers. We are presenting the information to you as we discovered it from reliable sources, and we encourage you to seek legal advice from a competent legal professional about your specific situation. If you're watching this video, you probably suspect that you've been the victim of a debt law violation. It can be hard to tell sometimes if the company has actually broken the law. To complicate matters, many debt collectors do not understand or care about debt collection law. Often, the people who are calling you are minimum wage employees who hate their jobs. The turnover rate at these debt collection agencies can be very high, so many have minimal training. Violations are extremely common. In this video, we'll discuss 5 possible debt law violation tactics that are currently used by many debt collectors. For our full list of potential violations, you will need to visit us online at lowincomerelief.com. Times and places. Debt collectors are not allowed to call you at certain times and places. They cannot call you before 8 a.m. or after 9 p.m. They cannot call you at work if they know that you aren't allowed to receive debt collection calls there. They also cannot call you at times or places that they know are inconvenient for you. Harassment. Under the law, debt collectors cannot harass you. They also cannot harass anyone else in an attempt to get to you. This means they can't call, hang up, and immediately call again. They cannot use profanity. They cannot shame or embarrass you. They cannot call anyone other than your spouse more than once in an attempt to contact you. Even if you gave them references, they can only call those people one time. They also cannot tell anyone other than you or your spouse that they are attempting to collect a debt. Employment. Debt collectors can only call you at work one time. If they know your employer does not approve of those calls, they cannot call you at work whatsoever. They are never allowed to call your boss about the debt. Nevertheless, debt collectors sometimes choose to break that law. In a Dateline episode from 2009, a debt collector named Joe told the interviewer, "One of the things that I like to do, which is pretty nasty though, is that I'll find out where somebody works, and then I'll find out who the owner of the company is. Find out their number and call them at home. I love that. Call the boss at home. That's my favorite thing to do." Of course, irritating your boss is designed to pressure you into paying the debt. The logic is that if your employer is irritated, your job is endangered, and if your job is endangered, you will be more cooperative with the collector. This tactic is absolutely illegal under the FDCPA. Threaten to sue. Debt collectors cannot threaten to sue you if they don't actually intend to do so. A common debt collection scam involves two debt collectors calling you at different times. The process usually goes something like this. Someone will call you from a blocked number and claim to be a process server from a local company. They'll say that they have legal paperwork that needs to be served on you right now because you are being sued in a nearby court. They'll give you a number for the company that is allegedly suing you. So you'll call that number that the so-called process server gave you, and the company will tell you that they are from the pre-litigation or pre-legal department and that they can only help you until you've been served. They'll repeatedly tell you that you are going to be served today and that you need to make a payment before you're served or you will not be able to negotiate the debt out of court. This has happened to me several times. I have always refused to comply, and I have never been sued as a result. It is a violation of debt law for someone to claim that they will sue you if they don't actually intend to do so. Refusal to validate. Another common debt law violation occurs when the debt collector refuses to validate the debt. Debt collectors are required to send you written notice that includes the amount of the alleged debt, the name of the creditor, and a notice of your right to dispute the debt. If you submit a written dispute, they must verify the debt and cannot collect until the debt has been verified. So what should you do if you suspect that you've been the victim of a debt law violation? If you suspect that you've been the victim of a debt law violation, you need to gather evidence of your experience immediately. Document the caller's name, the company, and the debt referenced by the collector. The more information you have, the better. Debt collectors who violate the FDCPA could owe you up to $1,000, in addition to any actual damages and reasonable attorney's fees. I maintain records on every debt collector that contacts me. I have successfully used this information to negotiate the amount that I owe. In some cases, the debt has been entirely forgiven because the company realized that they could potentially owe me far more than I allegedly owed them. If you have a strong enough case, you may sue the creditor directly. Many debt law attorneys will accept a strong case with a condition that you only pay if you prevail in court. If you prevail, the company you are suing will pay your attorney's fees anyway. The entire lawsuit may occur at no cost to you. For more information on debt law violation practices and free legal aid resources, visit our website online at lowincomerelief.com. Thanks for watching and have a great day.